Well, we've been following the Tata Mistry saga consistently and we're on top of all the news breaks right here on ET Now. So quick recap, the NCLAT overturned a former NCLT decision and reinstated Cyrus Mistry as executive chairman of Tata Sons over 3 years after he was ousted from the position in a surprise board meet in 2016. The Mistry camp has hailed the judgment as a vindication of its stand. But let's now get the other side of the story. Joining me now is Counsel for Tata Sons, Abhishek Manu Singhvi. Thank you so much, Mr. Singhvi, for speaking with us on ET Now. Let me start by asking your response to the NCLAT judgment, which has not only upheld Mr. Mistry's claim, but has made very scathing comments on the conduct of the Tata Sons board as well.
Let me start by saying that you are entitled and your viewers are entitled to discount everything I say, because I was the counsel for Tatas. So that certainly is a full disclosure at the outset, as everybody knows. But let me try and be as objective as possible. I find parts of the judgment completely unsustainable and indeed shocking as a lawyer, because they have adumbrated principles unknown to corporate law. Let me give you 4 or 5 quick examples, because without that your viewers will not understand. And for that reason I say that it is a very deeply flawed judgment, because it seems to have taken leave of corporate law principles altogether, elemental, fundamental principles. First, the overriding principle of corporate law is that corporate decision making is done by majority decision making. This judgment has turned that principle on its head, because majority decision making, right or wrong, has been ignored. Number 2, the direction that majorities and minorities should consult before appointments is bizarre, because that is also a complete overturning of the principle right from LIC escorts and so many other cases of majority decision making. Thirdly, assuming, and I am certainly not accepting, I am not conceding, but I am just assuming for the sake of argument, that Mr. Mistry's removal was bad or wrong in any manner. Even then, the third principle which is violated is that after an interval of 3 years, I don't know of any case where the executive chairpersonship of Tata Sons and of all the operating companies and the directorships of all those companies is to be reinstated and restored to Mr. Mistry.
Right.
Because this violates the basic principle that a employee who is not wanted, in whom the board has, the board has lost all confidence, will be foisted upon such employer, which is a very odd thing to do and is never done. And 2 other things that I have done. There are strange portions of the judgment which didn't really arise. No factual finding or adjudication is recorded, but a conclusion is given singling out Mr. Mistry as the only blameless person and specifically ascribing non-performance and loss, which really is not necessary in the judgment at all, to all the other non-Mistry directors, and more particularly Tata, Sonawala and Nohria. Again, something quite very unusual, uncalled for and totally wrong, because how can you decide that one director out of 11 was good and blameless and virtuous and all the others were wrong? And last, it is astonishing that Mr. Mistry specifically, affirmatively, categorically gave up his prayer for seeking restoration on the board as executive chairperson. That relief is granted. Though it is now stayed for 4 weeks, that relief is granted. Something which you have given up is granted. Now these are 5 out of at least 20, 30 such examples. I have given you the 5 main ones, and it shocks my understanding of corporate law.
Well, clearly, as you said it, you're coming from the side that has lost this particular battle. But I just want to draw your attention, Mr. Manu Singhvi, to parts of the judgment which highlight the unfairness of Mr. Mistry's removal. The claims made as an afterthought, in fact, of his non-performance, something the judgment says. And isn't that unfairness, as perceived by Mr. Mistry, at the very crux of the entire courtroom battle?
Assuming that he was wrongly removed, I am saying in law, the remedy, the result, the relief of reinstatement as chairman of a company which has removed him or as director is uncalled for, unheard of and extraordinary. That's one answer which you perhaps escaped your attention. Second, there is no basis for saying that of 11 directors, the only one blameless for losses and underperformance is Mr. Mistry, and the only persons to be blamed are all the others minus Mistry. This was not a trial court, this was not evidence led, this was not adjudicated, this was not argued. How is a finding given? How is a conclusion given? Thirdly, there is the prayer which you are saying, this removal which is at the heart of the whole matter. Yes. The removal at the heart of the whole matter, as far as executive chairpersonship is concerned, was expressly given up by Mistry. He said, assuming I am wrongly removed, please do not reinstate me as Mistry, as executive chairperson.
Yeah.
How do you answer that?
No, I get that point, and even now it's not clear whether he will actually come back as chairman. Post all of this, he said that, you know, even if I am reinstated, I don't want to come back. But he wanted to prove a point. Has he managed to prove a point? And the other point is of interference. Like the judgment says, there were 550 emails exchanged, micromanaging the running of the group. Doesn't all of this make this case stronger even as you move ahead?
All that you are saying is that he is the winner in the case, which is known to everyone. But what you are not noting is that even if he is a winner on the ground of wrongful removal, you cannot grant reinstatement to a person who says, I don't want it. Second point again you are missing, our argument was not at all based upon rightful and wrongful removal solely. That's another error, that's the sixth error. In addition to the 5 I have told you, our argument certainly involved the argument that it is not wrongful removal, it involved a separate argument altogether which the judges missed altogether. And that argument was that even if he is removed wrongfully, the removal is not on the basis of performance remuneration committee. It is not on that basis at all. A board of directors is entitled to lose confidence in you irrespective of performance. That confidence may be lost on several fronts. Partly performance, partly the fact that you are not trusted, partly the fact that people don't believe or like your conduct. That's the whole point of corporate law. A board is not supposed to give a reasoned order why it wants to remove.
Yeah.
And non-performance is certainly not the only reason. The board lost trust and confidence in a director or a chairman. How is it possible for a court to say, it's like saying your employee you lose faith and trust in, and it's adjudicated and is reinstated in a purely private corporate scenario, not in an industrial tribunal scenario, not in a government office scenario. How is that possible? That's the legal error. You asked about legal errors.
Yeah.
You don't have to ask me again and again that you lost. Of course we lost.
Well, Mr. Manu Singhvi, you lost, they won, he's been reinstated, but there is a pause for 4 weeks. Now, as those 4 weeks go forward and, you know, the next legal steps are being mulled over, there are also some suggestions that there could be some kind of a settlement, considering that these two families have long-standing cordial relationships before 2016 and the ouster of Mr. Mistry. Do you see this going down the road of settlement, or will it go down to the wire in a legal case?
Clients are always free to settle amongst themselves, but I don't see it happening at this late stage. There are 2 judgments, and judgments can't be set aside by consent. So this it's always open to all clients to decide, but at the moment I think it's a very theoretical, a very academic question. There is a judgment which will be challenged in the Supreme Court, and ultimately what happens in the Supreme Court, including settlement or mediation through the Supreme Court, cannot be ever ruled out.
Absolutely. Thank you so much, Abhishek Manu Singhvi, for speaking with us. The big exclusive conversation there on the Tata Cyrus Mistry saga that we're tracking continuously right here on ET Now. We'll take a very short break, but remember, this is the show that gives you the most value for your time if you spend 1 whole hour here. So coming after the break is an interview you must not miss. The Grand Master, Vishwanathan Anand, he's talking about his new book, Mind Master, but he's also talking about how his lessons from going to the top of his game as a champion chess player can be applied to all of our lives. Don't miss it.